bit about the background, research, and assessment process that led to the recommendations that drove what's in the bill. So just to set the stage in terms of this process, in 2019, the Juvenile Justice Commission was formed for 6 years to study and improve the juvenile justice system. As you can see on the slide, the scope of that commission was to review Chapter 2720, gather information around child welfare, receive reports and testimony in furtherance of the commission's duties, advise effective intervention, and annually submit language to the governor and legislative management on the findings and recommendations. So to support that process, the commission, in partnership with the SAG, put out an RFP for organizations to support an initial analysis to see where North Dakota was, where it had made improvements, and where potential areas of improvement existed. The Council of State Governments Justice Center was awarded that RFP and worked to look at how to position North Dakota to develop a consensus-based, data-driven statewide plan that ensured that juvenile justice systems more effectively protected public safety, reduced disparities, and improved outcomes for youth. In order to conduct this assessment, we reviewed analysis and reports that's related to past and current juvenile justice system, including annual reports, available data. We reviewed 2720, as well as any other legislative code that touched on juvenile justice statute, primarily exists within 2720, but there were a couple additional statutes that we also reviewed. And then conducted focus groups with a range of policymakers, DJS, juvenile court judges, and probation staff, prosecutors, public defenders, law enforcement, essentially anyone we could get on the phone that came into contact with the juvenile justice system or was involved in child welfare, to see how things were working on the ground, what people saw was working well on a day-to-day basis, as well as what people saw as opportunities for improvement. And then lastly, while we didn't have the opportunity as part of this assessment to do a really deep data dive looking at case level data, we did do an analysis of what North Dakota was able to collect and utilize data in terms of driving decision making, and how that data was being utilized in day-to-day practices to provide some recommendations on ways to improve that. I should take a step back and just give a little more information. CSG is a national nonprofit, nonpartisan organization. We work across the country in all 50 states, as well as Puerto Rico and the territories, to improve outcomes for those who come into contact with the criminal and juvenile justice system. So bringing that experience nationally and that knowledge of the research to this process. So through that analysis, both working nationally as well as comprehensive analysis of the available research, we look at juvenile justice systems through a lens of 4 key components to a successful juvenile justice system. The first component is that supervision, service, and resource allocation decisions are based on validated risks and needs assessments. So this is to say that tools around risk and needs are used to drive decision-making, and they're used to drive decision-making at the right points in time. Whether that's a risk level assessment or a needs assessment or a needs screening, that those tools are being utilized to drive decision-making. The research has shown consistently that even experienced practitioners struggle to properly identify the risks and specifically the criminogenic needs that are driving behavior. So when you look at youth, especially youth that are coming into contact with the juvenile justice system, they could have a wide range of needs, but there are specific needs that drove their contact with the juvenile justice system, and those need to be prioritized in order to effectively reduce recidivism and improve outcomes. On the risk side, when left to individual devices, people are heavily influenced by offense type, by a knowledge of a family's history or a youth history, and don't do as good a job as when supported by a validated tool in identifying what the right level of supervision is, where the right placement is. And so those tools need to be a part of the decision-making process. The second is to adopt and effectively implement programs and services demonstrated to reduce recidivism and improve other outcomes for youth, and then to use data to evaluate results and direct system improvements. So evidence-based services has somewhat become a catch-all term That means anything to anybody. So when we talk about that, it's really making sure that there is a coherent purpose to services. So there is a target population that it's designed for, that is the population it serves, that the right level of dosage is being provided to the right individuals, and that people are really tracking and making sure there is that quality assurance and fidelity to a model. So it's not just about having that alphabet soup of MST or FFT or those validated services, though obviously they exist nationally, but making sure that what does exist is utilizing tools and data to ensure that it is actually meeting the goals associated with. So when you look at something like FFT, that hasn't necessarily been validated for a Native American population. So when you're working within a state like North Dakota, you can't just say, well, we have FFT. Is the data being utilized to actually make sure that it's having the outcomes and is culturally competent and is effectively meeting the needs of the population that you're serving and using that to guide decision making. The third sort of core component is to employ a coordinated approach across service systems to address youth needs and promote positive youth development. So this is really looking at the ways in which, especially within juvenile justice systems, youth are often coming into contact with multiple systems. And when you look at youth and families, they'll have 7 or 8 case managers or caseworkers. They'll have requirements and case plans, and service systems aren't talking to each other. They're putting that onus on the youth and family to navigate these incredibly complex systems. Sometimes things are contradictory, sometimes they're redundant, and that causes youth and families to lose faith in the system and to not engage in the process. And so rather than putting the onus on youth and family to manage those systems, it's really putting it on service systems to collaborate effectively to say, how are we better serving this youth? How are we better serving this youth and family? And ensuring that case plans are done in a collaborative way, that services are being utilized effectively and prioritized for the right populations, and putting that all on service collaboration. And the fourth is that systems and policies, programs, and supervision are tailored to the development needs of adolescents. So the cognitive brain development research is really clear that youth and young adults are not just mini adults. They're developmentally distinct and a developmentally distinct population from adults. They react to degrees of punishment differently. Regular adolescent behavior is to be testing boundaries. They're more susceptible to peer influences. They're less reactive to long-term consequences. So really thinking through the existing brain research to make sure that systems exist to build on that and to be tailored to that. So when you talk about something like incentives or sanctions to drive positive youth development, what the research has shown is you need at least 3 positive rewards for good behavior change for every 1 negative consequence for bad behavior in order to really drive a true change in positive development. So making sure that that research and knowledge is built into everything within the system. So within that framing, when we conducted this analysis for North Dakota, what we found was that North Dakota lacked a statewide vision, purpose, and set of research-based principles to guide its juvenile justice system. And to be clear, that doesn't mean that there was no pockets of practice happening where there has been progress made or was reflections of all of these things, but that it was happening in pockets and not in a coordinated way across multiple service systems to meet the needs of youth. This is somewhat exacerbated, and we'll talk a little bit about this in number 4, but by the fact that 2720 really combines child welfare, delinquent, and unruly youth into one code. And this creates a muddled vision of what each purpose is for, what services were available, and it just creates a situation where different service systems, different levels, and different individuals working within the system weren't having a coordinated approach with a shared vision and a shared mission statement around what the juvenile justice system was meant to do and what its primary purpose was. We also found that North Dakota offers limited access to services without system involvement and has an over-reliance on residential services. And I think that's something we're going to talk about a little bit today. But really what we've heard consistently was that oftentimes calling the cops was the only way that people knew how to get access to services, even for youth they knew weren't a public safety risk. This is especially true for unruly youth, but was also true for a range of other youth within the system, where what you're looking at is people just being desperate for services, not actually seeing a public safety risk. And what we know from the research is that bringing youth who aren't a public safety risk into a juvenile justice system makes them more likely to recidivate, makes them a greater public safety risk, and leads to worse outcomes than no services at all, let alone properly receiving services outside of the community, outside of the justice system and in the community. So really making sure that the justice system isn't being turned into a service delivery system is a key component of these reforms. The third is that North Dakota has limited capacity for evidence-based service delivery, quality assurance, and data-driven decisions. Similar to the first point, that's not to say that there aren't places where that's happening in the state, but overall, the ability to use evidence and data to ensure that the services that do exist are meeting their goals, and if not, identifying strategies to work to get them there is not something that was happening consistently across the state. And then to the fourth point, which loops back into the first, which is that 2720 was overly general, vague, and because it had not been really redone since the late 60s, was lacking in some of that language and recognition of new research and evidence-based practices and policies. So based off those findings, CSG made a number of key recommendations to the Commission and SAG. The first was to decriminalize unruly behaviors and develop pathways to serve these youth outside of the justice system, to establish more stringent criteria and research-based processes for system decisions, particularly around detention and out-of-home placement, to build a more robust continuum of community-based services statewide, as well as for specific populations and communities, to strengthen statewide commitment to and capacity for evidence-based services, quality assurance, and data collection, and to align state statute with system improvement recommendations more generally and research best practice to provide that foundation to allow those reform efforts that were already happening within the state a stronger foundation and to provide more support to those ongoing reforms that were happening in the state already, and to ensure that it was truly happening statewide and not just within specific pieces of the system. So taking those recommendations, a group from North Dakota put together this bill draft, and I'll turn it over to Karen to talk a little bit more detail about what is included in the bill.
Okay, thanks, Jacob. Good afternoon, everybody. It's nice to see you, even if I'm just seeing your little blips on the screen. Basically, we took all of these CSG recommendations that we've been getting over the years, and you can see this timeline shows you that this isn't something that just kind of came up this summer, but it really started almost 5 years ago when Court Administrator Scott Johnson and Justice McEvers and Lisa Johnner and Judge Fontaine did a visit to the CSG 50 State Forum and had a chance to talk and be exposed to different elements of juvenile justice reform. And that led to a lot of talk about what we could do in North Dakota and then some technical assistance requests. So CSG, as Jacob explained, has been to North Dakota a couple different times. And in that first couple of visits, we took their recommendations and implemented changes in our policy or procedure, but there weren't statutory changes. And it was clear that in order to make really big changes, we needed to restructure our pretty dated statute in Chapter 2720. So the timeline just gives you a little chance to see how long we actually have been talking about this with a number of groups and a number of stakeholders. So when the written recommendations of the last CSG visit came to us I think on June 1st, we took that letter, and Representative Clemeen really wanted the Commission on Juvenile Justice to work in this session, because we're a time-limited group, we're only 6 years in length, to try to restructure Chapter 2720 and kind of provide a better framework to move towards a lot of these reform efforts. So a work group was formed, and that started in June. It was Representative Clemeen, Representative Kim Koppelman, Senator Larson, Senator Bakke, Lisa Biergard, Lisa Johnner, Corey, myself, Travis Fink from Indigent Defense, and Tessa Vaughan from the Burleigh County State's Attorney's Office. We basically peeled apart 2720, and we'll talk a little bit about that structure. But the very first draft was introduced at interim judiciary on July 22nd. And then a number of comments were received. I think it was 4 or 5 pages, single-spaced of comments from different stakeholder groups. We met in August and early September to address those comments, and a revised bill was presented at the Interim Judiciary Committee on September 24th. Since then, we have continued to meet and are working on some amendments just to clear up some typos and some areas where we weren't getting the language that we needed to accomplish what we wanted. So to talk about first, just really the structure, because that's the most noticeable difference, I think, when you first are able to take a look at the bill draft. As you know, because you're all practitioners, Chapter 2720 is very dated, dates back to the 60s, and kind of the older parens patriae, the state as parent model of juvenile justice. And in 2720 is interwoven statutes that have to do with delinquent, have to do with unruly, have to do with deprived, sometimes all in the same paragraph or the same subsection. So for a new practitioner, if you're a new attorney, new social worker, new juvenile court officer, new DJS worker, it really does require quite a bit of practice and observation in the courtroom and in meetings to understand how these different sentences actually play out in a case, because one sentence will actually apply only to deprived youth, another will apply to delinquent, and you all know that it is a confusing read. And so there's a lot of underlying policy and procedure that we all adhere to, but that lack of transparency makes it really difficult, I think, not just for new practitioners, but for the kids and families that we interact with. So pulling apart 2720, what the plan is to do is to have that guardianship chapter, which was new last session, have that at the top, that 2720.1. And then 2720.2, we made these subsections based on case type. 2720.2 is the Juvenile Court Act, and it has updated definitions and then the sections that will apply to all of the subsections. 2720.3 was our work group discussion and decision to ask in the amended bill draft to, instead of using that older term of unruly child, to instead use child in need of services, or CHINs. And then instead of deprived child, use child in need of protection, CHIPs. And there are other states that use those types of acronyms. So that section has to do with those case types. And then to put all of the delinquency into its own subsection, 2720.4. And then our discussion was having the Division of Juvenile Services section, which is currently 2721 at the tail end. That actually didn't end up making it into the bill draft, but ultimately we're kind of viewing this as a continuum, as a system, and having those all together. And you'll see in each section, when you take a look at them, you probably already have, that each section has its own definitions, and they're up to date. We've added new definitions, not new, but words that we use all the time in practice. Things like graduated sanctions and restorative justice and accountability. Those are words we've used for a decade, but they aren't defined in our statute. And then there are lots of places in 2720 where it's silent about who's doing what. And where it's been silent, it's left to be those holes filled in by really regional practice. So in some areas, it might be the judge's staff, and others, it might be clerks, it might be juvenile court officers, it might be social service workers. So some of that silence, we've tried to fill in some of those responsibilities just to have a clearer practice across the state. So that's the reorganization, which I think was long overdue. And then talking, following up on what Jacob talked about as far as what works with kids in the system, we really wanted to peel apart those unruly or those status offenses. And so, as you know, currently our definition of unruly encompasses ungovernable, running away, truancy, minor in consumption, minor in possession, and then use of tobacco under 14. And so the plan is to allow those kids and those families to access services without needing an arrest or a referral to court. Now, in the amendments that you're going to see coming soon, what we ultimately have decided to do is keep the minor consumption, minor in possession in the delinquency section, so that youth who contest those charges have an opportunity to have access to a court process. Because there are driving implications and other legal implications for those types of charges. I think a long-range goal would be to try to move those MICs and MIPs strictly to a service-based process, but this is a step forward by doing it this way. So the amendment also, if we pull that up, but we're also talking about delaying the start of that CHINs referrals to the zones until August of 2022. And please interrupt me, Jacob, Corey, or the Lisas if I'm misspeaking, because I've done this enough now that maybe I'm got it a little confused in my head. But ultimately the delay is that until August of 2022, those CHINs referrals would still come to the juvenile courts if the bill passes, but our response to those would all be diversion. That actually isn't shocking at all, because the vast majority of unruly referrals that we receive today or even last year or the year before, are all primarily getting diverted. And if you're interested in those numbers, I've shared them with the group and I can sure show those to you. But the vast majority of those unruly type status offenses are being diverted to services. So the court would continue to intake those until August of 2022, at which point the bill, if passed, would have those referrals going to the zones. Also, it requires in that CHIN section that schools make a more of an effort to let us, the system, know what they've done on the educational side to approach parents and kids about unruly behaviors. So right now, currently 2720 is silent, pretty silent about how you make a referral to court other than you just send it to the juvenile court. So the schools can literally just send us a cover letter with an attendance record and not indicate to us what efforts they've made. Now, many school districts do have truancy attendance boards. Some of them have attendance officers, but it's kind of hit and miss, as you know, across the state. And where they're currently not required to let us know if a student that they're referring for unruly behavior qualifies for IDEA or any special education services. So the bill draft would require that. Also, the bill draft limits some delinquencies being referred to us, but not until 2023. So also requires the use of risk and needs screenings tools, which you're all aware that we use the YAZI with our delinquent youth. The YAZI is validated in North Dakota for use with youth with a delinquent charge. We can use it with kids with unruly referrals as long as they also have a delinquent history or a current delinquent charge, but it is not a valid tool for unruly youth. But the statute will require the use of a risk and needs screening tool at intake to guide our decision making. So I think that's something we've been doing, but this puts it into statute. Something I'm probably the most excited about is the broadened right to counsel. In the delinquency section, there's a presumption of a right to counsel for children in all case types and then also for parents at detention hearings. So I know Travis Fink has been requesting some additional funds from the legislature to support the use of those indigent defense funds. But I think we would see, if this passes, we'd see fewer continuances, which could lessen the amount of time kids spend in detention or any of those pretrial settings when they're out of home. So I also think we'd also see fewer kids making admissions to offenses when they're not really sure what they're admitting to or what the consequences are. It also requires the use of that risk and needs tool ahead of time and then filing that with the court and making that part of a disposition recommendation to make sure everybody's fully on board with using that science to match kids to the right service. There's also a shortening of the length of probation and a reduction in the probation extensions that we can use. So basically, we can't just keep extending probation for very minor violations. There has to be a significant risk to public safety or treatment needs before we would continue probation. Also, there's a specific active efforts statute. So we bring that federal law into a state statute, which I know we've in many areas talked about for years. And I think that'll put it front and center for the attorneys who practice in this area and also for the judges. And it'll probably be really nice for zone staff so that it's really clear what the definition of active efforts is and how they can satisfy that federal requirement. So, kind of on talking about the delinquency side, we really want to reduce the use of out-of-home placement unless kids are really presenting as a public safety risk. So we're going to further limit the use of secure detention. We've been doing this over the past few years, as I'm sure you've seen or heard about. We continue to use a detention screening tool, but the bill draft, if you read about the section on detention, makes it clear which types of kids pose a public safety risk and in which case secure detention can be used. There's also discussion about probation violations, making sure that we're using probation sanctions, also using incentives like Jacob talked about for good behavior, and then also wanting to have a better planning process around what types of evidence-based services, community-based services that we need so that every youth can receive high quality services and it's not really geography-based. So I think that is the end of the PowerPoint with the summary. And correct me if I'm wrong, were we just going to entertain questions or at this point, or if you wanted further specific questions about the bill, we could pull up the bill draft too.
Yeah, thanks, Karen. I would like to open it up for questions now if anybody has any feedback or questions.
This is Kim Jacobson. I apologize. I'm traveling, so I'm participating by phone today, so I'm not able to see the PowerPoint slides. But I did have a question. Karen, you mentioned that there'd be an opportunity for increased counsel for children, and you're referring to more the juvenile type proceedings. Will that be also available for children that are subject to CHINs, or is that mostly for CHIPs?
Yeah, I was going to pull that up really quick. I believe it also applies to kids in a deprived action, as long as if they're 14 or older. I know, Corey, Lisa, I'm digging in my draft right now.
I was thinking it was more on the delinquency side, but if it was going to be for the CHIPs, it would have to be for those that are parties at 14 and over.
Yeah. It's on page 41 of the bill draft. They can waive their right to counsel if they're 14 or older, and the waiver is knowing, voluntary, or intelligently made. And detention hearings for parents, dispositional stage for parents. And it says that all proceedings in a child in need of services or protection, that's for parents too. So it says a child may, they also have the right to indigent defense at a informal adjustment. So yeah, it's primarily has to do with the delinquency section. That's right. But there really won't be a court procedure for the CHINs kids. It'll be diversion. In a CHIPS case. Yeah, in a CHIPS case, you know, the child obviously would have a lay guardian ad litem and an opportunity to have counsel if the judge thinks that's appropriate.
Yes, I was just wondering how those two pieces were going to intersect, if it was going to replace guardian ad litem or be in addition to, so that helps clarify that.
Yeah, I mean, I think we look at the lay guardian ad litem program continuing, and that their role of, you know, doing that kind of pre-adjudicatory investigation and then making a report to the court will continue just as you currently see it.
Any other questions or feedback?
Looks like Scott's got his hand up.
Yeah.
Good afternoon. Thank you. My question is, with the CHINs group and the referral to the zones in August of 2022, how does the case management look, and how does it fit with the safety framework practice model?
Yeah, so I can speak a little bit to that, Scott. So quite honestly, giving it a year delayed implementation is actually going to give us time to build what we need for that group. I think what we would do is really look at grabbing what juvenile court has done over the last decade, which has been not case managing most of those kids. That would not be a goal. Those are light touch kids unless they're already involved in deprivation proceedings with the zones already. And many, as we know, already are involved in deprivation case management or in-home cases that end up running away or skipping school and things like that. So if they're first time and they're not involved in the zones, I mean, we want them to be as light touch as possible. So I think we would join forces with the juvenile court, look at what they've done over time, referring kids to services, not case managing them. Karen certainly knows the data better than I do on how many cases they truly case managed in that group.
Yep. If it's helpful, I'll just pull up the slides we had done before, if I can do it. Are you seeing that slide with my chart?
Yep, it's coming up. Here it is.
Yes. Okay. So we had kind of taken a look at 2019 at the unruly referrals. And so this slide that I pulled up, it shows 2019 unruly referrals by type. And then it also shows whether or not they were also delinquent. So even after August of 2022, there will be kids who commit a theft of motor vehicle while they're running away. So the runaway would go to the zones, the theft of motor vehicle will come to the courts, and those kids could be receiving services on the juvenile court side. But you can see in 2019, basically these pink or salmon colored, that shows kids who had no other delinquency at all. They were basically, first timers. They may have had underlying child abuse and neglect cases, but this smaller number were cases that also had delinquencies at the same time. And keep in mind, we're not talking about having the MIPs, MICs come to you. So those alcohol offenses. And then I also had these slides worked up just a little bit, just showing the extent to which we have used diversion. So this slide is MICs, MIP. You can see, a large percentage were diverted and only 79 went on to probation. And more likely than not, those were kids who, had other delinquencies tied to their alcohol use. Here you can see curfew referrals. Vast majority were diverted. This next slide is runaways. Vast majority were diverted. Many here were dismissed or declined. Only 30 ended up on probation, and those were ones that probably were combo cases with delinquencies at the same time. Only 11 ended up in some sort of a custodial situation. My guess is those were dual status type youth. These are, youth.
Some of those are running from facilities or placements.
Oh, very true. Yep, good catch. True. Here is the use of tobacco under 14. You can see in 2019, there were only 92 of those. Kids over 14 go to regular, they get a ticket and they go to municipal court and pay a ticket. So kids under 14 come to the juvenile court. And typically we are diverting those to a public health tobacco class. So that's something I presume the zones could do also. So a vast majority of those get diverted or declined. Here are the truancy referrals. In 2019, 314, vast majority diverted, 53 received a probation. And my guess is that those ones with probation also had delinquencies at the same time, some combination or else some pretty chronic truancy cases there. We have kind of these ungovernable, so like disobeying parent, otherwise unruly. And then there was a catch-all, but you can see the vast majority of these were diverted. So I think that's what the zones then would be looking at, is forming a triage, correct me if I'm wrong, but some sort of triage with access to diversion services.
Yeah, either a matrix or triage. I mean, that would be something that this group, the zone directors or supervisors could really flush out with the help of what you guys have done over the years. Jacob, could you speak, because it kind of goes to the work, in the next couple of years. Jacob, could you kind of speak to kind of the work you're going to continue with North Dakota and how you could support kind of the work we would have to do around some of these things as we change?
Yeah, thanks, Corey. And I think what Karen was just talking about in terms of, one of the concerns we've had is that this change may result in youth having less access to services than they currently do. And as you can see from the slides that Karen was just talking about, that's not going to be the case. However, the implementation process is going to be ensuring that the process exists and the services exist and the right services are identified to ensure that these youth are receiving services in a timely and effective manner. And so one of the exciting things that have happened is that North Dakota and CSG applied for and received OJJDP funds. And so CSG will be continuing to work with the state of North Dakota for the next 3 years through hopefully the implementation of this bill, including the creation of some task force and working group members that are going to be cross systems to, facilitate these conversations and ensure the policies and practices that need to be in place are in for these implementation dates. So, we'll be facilitating and supporting that group, which will include, members from like this organization, as well as from the schools, from law enforcement, from court staff, to really talk through and work through what are the policies and procedures that are currently in place right now, what services currently exist, and then what needs to happen in order to make sure that there will be that effective transition and service system delivery when the effective date does come around in 2023. And so, that this is an ongoing process, it's an iterative process to make sure that this is going to work. But, this is something that we've done in other states and have built these cross systems groups and work through these. We're doing it in Colorado right now, and have seen what can be effective and can help walk North Dakota through that process and find what's going to work for the state specifically.
Any other questions or feedback for the group?
Can I just get a better sense of what kind of numbers we might be looking at as far as the tidal wave that's heading our direction? I'm just, I'm not really, I'm just trying to figure out how we have room for all of this. And so I might have a completely skewed idea of what the numbers might be. And so that's what I'm looking for.
Yeah, that's a good question, Melissa. Karen does have those broke out by county. We can look at those.
Yeah.
Also to keep in mind, I think the other thing to keep in mind is these aren't new families to most of you on this call. They are families you currently work with now, you know, and working from both sides of this. Many times I would be the director in Bismarck and read police reports that said, you know, my CPS worker told me to call the police when my child ran away. So many times there's a combination of situations where the zones are already working with a lot of these families, so they're not brand new kids coming your way. It's maybe more issues or new issues that are coming your way. But I know juvenile court does a nice job breaking it out by county. So Melissa, you could get kind of some trend data if you wanted to, and just your ward area. If you.
I did. I think I pulled up on the screen the 2019 by human service zone.
Yep, I got it.
So anyway, you can take a look. I mean, the largest, you know, group of unique children was 380 in Cass. You know, so you can get a sense, and then Burley 251. So if you can see that, and I have it actually broken out county by county. So if you're interested in that, I can send that to Lisa and she could share it with everyone. And keep in mind, this is 2019. We used 2019 at the time because 2020 is such an odd year. I did take a look at 2020 data, and we're just a little bit below 2019, but we've definitely had fewer school-based referrals this year. But that gives you an idea, and I agree with Corey that many of these kids are kids and families you're very familiar with and often have open cases on anyway.
Yeah, and I will.
Karen, would you mind sending that on to Lisa, because like some of us aren't there to see the screen right
sure.
now?
Yep.
That would be helpful.
Yeah.
Thank you.
Yep, absolutely.
Yeah. And also, you know, some of what I talked about at the beginning of this is, and you know, try to, whenever we do these assessments, it can feel negative because we do focus on the potential areas for improvement, but there are, you know, also see a lot of really good things that are happening in the states. In North Dakota, for example, has also been working on the dual status youth initiative, you know, and strategies for those youth and families who are in both systems. And so, you know, some of those policies are in place, but this, you know, that's also part of the implementation process, is looking at that data that Karen was just talking about and Corey was just talking about, and saying, you know, what does currently exist and where are those resource gaps. And so, you know, that's something that would be exciting to do no matter what, even if nothing was changing in the state. But in conjunction with this potential shift, provides a real opportunity for looking at that resource allocation and making sure that what needs to exist does exist in the right parts of the state to meet the right needs of the youth. So, you know, it's an exciting opportunity to take that step back and look at the data and say, okay, what do we need to do to make sure that these families are being served appropriately and that we're getting them the services that they need.
Anything else? Any other questions, feedback? Just looking to see if anybody has their hand up. I don't see anything. Okay,
Sure.
the
only thing I'd add, certainly, you know, someone from the zones, if it's Steve or Kim, whoever, will have testimony of some sort. So, you know, obviously, zone directors, if you have feedback for testimony for the bill, let us know.
Okay, thanks everyone for participating. I think I will go ahead and just email out the link to the PowerPoint presentation as well as the video recording once it's been able to be uploaded. And then I will include the data that Karen is planning to share so you can see that breakdown. Anything else? Any other questions or requests for data or anything? Okay, thank you.
Thank you.
Thank you all.
Thank you.
Thank you, Lisa.